The next case to come before the court is State of Ohio versus Courtney Buzek. Good morning. The court has read the briefs. We're prepared to hear arguments. You both will have 15 minutes, and you may reserve up to 5.
Thank you, Your Honor. May it please the court, counsel, Attorney Michael Krevling here on behalf of the appellant, Ms. Courtney Buzek. I would request the 5 minutes to be.
That's fine.
Thank you. Your Honor, this case is a unique case in that it is an argument for ineffective assistance of counsel for a drug DUI case. The quick facts of the case are that the appellant, Ms. Buzek, was involved in a fender bender. Police were called. It was her fault. She was subsequently taken back to the station where they did a urine toxicology. The toxicology came back 0 ethanol and bupropion.
Excuse me.
Yes, Your Honor.
Bupropion?
Yes, Your Honor.
What is that?
It is a prescription drug used in Wellbutrin, which my client had a prescription for. The toxicology report was obviously understood by counsel to have had the bupropion.
Excuse me for just a moment.
Yes.
I want to ask this question in response to something you said before I forget. You said that your client had a prescription for Wellbutrin, and the bupropion is an element of that. Did your client testify?
She did not, Your Honor.
How does it come in to evidence that she had a prescription for it?
When the toxicology came back, it was made known that that was the only thing that came forward was the bupropion, which is Wellbutrin. It is in the officer's notes as well as pretty much everything else. So she had to have, at some point in time, it's in the file, let them know, yes, it was a prescription Wellbutrin. That's really about the only drug out there that uses bupropion, which
I understand that. I just, from reading the briefs, it's difficult to discern how the information regarding her having a prescription could come into evidence without testifying.
And in fact, Your Honor, that is one of my biggest arguments in this case. The counsel at trial pled my client no contest with stipulations without presenting any real evidence, without filing for a bill of particulars or filing a motion to suppress. The toxicology report came back without a quantity. There is no quantity amount even of this.
Is the toxicology report even in there?
It wasn't before the court. It was in the brief filed by, well, actually filed by prior counsel in this case.
But
I had a big...
But we're only allowed, I'm sorry, Judge. You're probably going to say the same
Same
thing.
thing, you do it.
Yeah.
We can only look at what's in the records.
You can, Your Honor, but as ineffective assistance, I can say that that was exculpatory evidence that needed to be placed there. The lack of quantity.
But you know, usually, I know this is a misdemeanor case, but usually that's why we use a post-conviction plea.
Yes, Your Honor. This would have been her third DUI, 30 days in jail. Of course, took her truck, etc. Getting the information before the court, whether it be through a standard run-of-the-mill bill of particulars, a motion to suppress after the counsel found that there was this obviously exculpatory evidence, it is, in my belief, massively unreasonable. I do believe that it falls beneath the range of professionally competent assistance in pleading no contest before getting that type of information in, before letting even the court know how exculpatory some of this information could be, Your Honor.
Why did they ask for toxicology? Why did they ask for the test?
We can only guess based on the information provided by the officer, but they must have presumed there was something wrong with the
Her eyes were
appellant.
dilated, she was staggering, she was...
Right, there were a number of things, by the way, none of which actually fall under bupropion, which doesn't even have a driving restriction. I mean, bupropion doesn't fit at all. This is a horrible case to simply plea and stipulate to. Even a reading of the facts would have been perhaps okay. I would seriously argue, and the reason I added the State versus Houston is because I believe it quite effectively goes through the current law on establishing a nexus between a drug of abuse and an impaired condition. By the way, I think we have the same panel as State versus Collins from this district.
Of course, in that case, the officer had no idea what the drug was.
Correct.
And did not say anything. At least here, there is apparently a toxicology.
There is a prescription drug, but that prescription drug, again, doesn't even have driving restrictions. I believe
Well,
that.
you're saying that, but
Yes, you're correct.
do we have that in the record?
There's nothing in that record that would have supported Ms. Buzek's obvious exculpatory evidence. I don't believe that in a case like this, it fits within a normal, professionally competent attorney's assistance to please somebody and stipulate without getting some of the evidence out there that they knew at the time. It does show that they were aware that, first of all, that it was a drug case. Subsequently, I guess at the sentencing, they even mentioned the prescription, although incorrectly saying he thought perhaps it was within the numbers that would have been within her prescription. In other words, not showing an intentional abuse of it. But the reality of it is he didn't even have any numbers. The counsel was wrong about that. There are no numbers. So the inability in this case for the state to argue against an attorney's argument that, hey, you can't say there's more than a trace amount in this urine. You can't. It could be anything within the spectrum. The failure of doing that led to an automatic conviction in a case that is probably extremely winnable. I mean, not just a reasonable probability of an outcome being different, but a high likelihood that the outcome would have been different. Cross-examination at a suppression hearing, even forcing the prosecution to just turn over on a bill of particulars, here's exactly what we're saying, and here's why we're saying the bupropion in her bloodstream led her to have A, B, C, and D. Anything like that would have been perhaps better than having nothing at all and simply walking the person through. And I know we give a great deal of latitude to attorneys, and obviously being an attorney, I appreciate that. But I have struggled to find any reason where pleading no contest would benefit Ms. Buzek versus getting the evidence into the record. I just don't see how it could possibly help. Certainly in Collins, they didn't know what drug they was using, and there was no testimony. But at least in Collins, Your Honors, they actually were anticipating it was a true drug of abuse, a scheduled drug. Bupropion is not even a scheduled drug. This is, I'm trying to think of something to liken it to. It's like Lipitor, in that it has no driving restrictions. It has no anticipation that it will affect the person. So if you're not going to have a scheduled drug, there are things that require a prescription. I understand that you can work your way through that. But to presume a DUI based on a non-scheduled drug, even if it is a prescription drug, just because it's there, even without a quantity, it just goes beyond reasonableness. And I really believe that if this case were to be sent back, we'd be able to probably settle it. But more likely than not, if we had the testimony, it would certainly be beneficial, and the likely outcome would change. Just getting the correct information in that file. Thank you, Your Honor. Unless there's other questions, I'll just reserve
I don't
any
think so.
time. Thank you. Oops.
Morning again, Tom Morris, still from the city of Wadsworth. September 17, 2013, Courtney Buzek was operating a motor vehicle in a way that caused a collision in Wadsworth. At the scene, she had slurred speech, she was lethargic, she had constricted pupils. She admitted to taking Zoloft, Wellbutrin, Suboxone, and then later, afterwards investigated by the officer, admitted to taking Klonopin. There was a drug recognition expert that came on to interviewed her, conducted a series of field sobriety tests for her, used his expertise to determine what drugs he believed she was impaired by, and came up with the conclusion that she was under a CNS depressant, central nervous system depressant, and a narcotic. He said, based on a reasonable degree of certainty, based on his expertise, she was unsafe to drive. That's what he would have testified to. We never got there.
And where is that in the record?
It's not, because we never got there.
You didn't proffer it and then get,
There was no motions to suppress. There was nothing. There was a plea. This information was all presented to his counsel. His counsel reviewed, or her counsel, I'm sorry, her counsel reviewed the police report, reviewed the drug screen, reviewed the drug recognition expert, and made a conclusion. I don't know what her conclusion was, but after consulting with her client changed her plea.
Well, let's go back to the laundry list of drugs that
Sure.
Ms. Buzek admitted to the officer to taking. Was there anything before the court that will be in the record before us as to when those drugs were taken and whether or not those are prescription?
Absolutely not. There's nothing in the record that would show that because we didn't have trial on that. Every case that we're talking about, particularly those cited by the defendant, talk about cases where there's a trial. Is there a nexus between this and this? Yeah, we need a nexus. We agree with that. This court said it, so of course we agree with it. What's that nexus? That nexus is a drug recognition expert. We had it in this case, but we didn't have a trial. Once you enter a plea of no, I'm sorry.
No, you're fine. I just don't know, because both sides are presenting stuff that's not in the record, so it's just difficult.
My point is, it is difficult to do that. That's why you should turn down the appeal, because there's not enough information in front of you, because there wasn't a trial. The way this should have shaken out isn't through a motion to suppress or a bill of particulars. I don't know what he's trying to suppress in this case. I don't know what a bill of particulars would have gotten you other than the date and the time when it happened. What it should have been is he should have she should have attempted to withdraw her plea, had a hearing on it, and said we had a substantial likelihood of success other than the fact that we didn't know about this, or there was this, or we have new information, or something else. Have put all that on the record. Then I could have had an officer come testify and say, these are the things I saw. I could have had a pharmacologist come up there and say, these things are prescriptions, therefore they're dangerous drugs, therefore they're within the Controlled Substance Act, whatever that may be,
Well,
instead of having me try to do that.
Except that the toxicology report, which may be in the record and may not be in the record, at least it's being argued, and perhaps this is part of the stipulation, only included one substance.
Sure.
Correct?
Sure.
So all these other drugs that she allegedly said that she was taking really aren't relevant, are they?
If this was a trial, what I would do is I would have a pharmacist come in and testify that these testing procedures, the way they happen, they have a cutoff level. And at that cutoff level, everything below comes up negative, everything above comes up positive. So they do a general, it's called an amino assay test, when they're testing all the different kinds of drugs. They don't go down like a breath test where it says you have a 0.1 or we'll take it all the way down to 0.0001. They'll tell you that. These tests don't do that. So the situation, if we put it in different terms, would be imagine someone who tests a 0.079, then takes a Xanax and then takes another drug. Under the amino acid test, unless they hit a threshold, it's going to come up negative for everything, even though those things combined would cause a horrible effect. Now, am I a pharmacist? No, absolutely. How am I telling you this? It's not based on that. It would be inappropriate for me to testify about this. But I would have an expert to do that if we would have had a trial. I would have an expert to do that if we were even on a motion to reopen the case. That would have given you the information you need in order to make your judgment.
When she pled no contest, was there a waiver of revocation of facts?
Once again, I apologize, I was not there. I can tell you this, on every third offense case, Judge McIlvain will state, by this, I assume you acknowledge that you consumed some amount of a drug of abuse and it impaired your ability to drive. That is what he typically says on a third offense back when he was doing no contest pleas. So the only relevant hearing in this case, I think, my humble opinion, is the change of plea date. Was it done knowingly, intelligently, and voluntarily? The question is not, but for ineffective assistance of counsel, would she have entered the plea? It's not the question. The question is, did the attorney do something to preclude the defendant from entering her plea knowingly, intelligently, and voluntarily? Because Judge McLean had his questions, and he goes over them all, and they're quite lengthy, and at the end he makes sure that she understands what she's doing, and they say yes, and they acknowledge that it impaired their ability to drive. He accepts their plea, makes a finding of guilty, and away they go. That is the important hearing. Was it knowingly, intelligently, and voluntarily? And if it is, then we're done. All these questions that would try to make me be a pharmacist or the defense counsel be a pharmacist isn't fair to do, because that's not in front of the record. Bill, a motion to suppress, they said that maybe should have a motion to suppress. I don't know what that would have looked like. Motion to suppress what? Suppress the evidence that they would want to present most prominently, the toxicology report. So it really isn't a motion to suppress. This one was right for trial. If they wanted a trial and had their day of court, there would have been witnesses that came in, a drug recognition expert, and all those good things. And the defense counsel at the time knew about that. And she said, advised her client, and her client at that point decided to plead no contest to the charges and received a benefit. The assured clear distance was dismissed, so she took a benefit. Only after she was sentenced did this come up in terms of, and certainly the judge in his Rule 11 told her what the possible sentences would be, and that's a minimum sentence under the third offense. So, the bill of particulars as well, I don't know what that would have told, other than on September 17th, she operated a motor vehicle under the influence of alcohol or drugs of abuse. That's all the bill of particulars would have said. None of that evidence that they're trying to get would have gotten in front of me there. Should have been a trial. By entering a plea, she waives the ineffective assistance of counsel, other than for the purposes of her or the counsel doing something which precluded her from entering that plea knowingly, intelligently, and voluntarily.
Thank you, counsel. You still have 5 minutes.
Thank you, Your Honor. Your Honors, respectively, I have to completely disagree with opposing counsel on what this case is about. It's not a waiver case. Obviously, the question was asked, was there a recitation of the facts? There was not. There is an audio, I've reviewed it. In fact, the audio shows my client questioning her counsel, are they going to know blah, blah, blah. And I can't understand what she's saying, unfortunately. She said, don't worry, they'll get to that in the pre-sentence investigation. There was a waiver of the reading of the facts. Nothing was presented to the court. In fact, the court at first thought it was an alcohol case. And somebody had to say, no, drug of abuse. Oh, drug of abuse. There was no evidence presented there. It is also, by the way, not a narcotic case, which really probably the reason they even bothered to do the urine test. They presumed it was a narcotic case. Opposing counsel is incorrect as to the reason for my client stating what she had. She hadn't said she had taken all of these things. They had questioned her as to, when they did the urine drop, what prescriptions do you have? That is her list of prescriptions that she would have, but she hadn't said she had taken any of them. And again, the only thing that comes up is ibuprofen.
Well, how are we going to know that?
The only thing that we know is that she is saying that it was prescription and it's in the sentencing. And the sentencing portion of it, her counsel, separate counsel at that point in time, states that it was within his belief the range of her prescription. He's also incorrect. It doesn't have a range. But the end result was, this is a failure of counsel to get the evidence in. The reason we're all struggling is because of the lack of evidence.
Well, the reason we're struggling is because there's no record. That's
But-
why we're struggling, and there's no PCR for municipal court cases, or for misdemeanor cases.
True, Your Honor. A minimum representation, minimum level of representation in this case would have gotten that record before pleading and stipulating to a plea.
So in every case, in every misdemeanor case, would you have us rule as a matter of law that before counsel has a client plead, no contest, that there must be recitation of the facts or counsel is ineffective?
Absolutely not, Your Honor.
Well-
Were there exculpatory evidence that the attorney was aware of? I would certainly request that it be something that be presented. The judge needs to know it. I mean, the judge can't even
How do we
interfere.
know that?
Pardon?
But how do we know that? So the only way would be like Judge Moore is saying, and that would be just a blanket ruling, general ruling, that there has to always be a recitation of the facts, so there's a record.
If a reasonable attorney has something in front of him saying no ethanol and no quantity of a non-scheduled drug, and that's all they have, a reasonable attorney is going to make certain that gets in the file.
But we don't even have that. We don't even have that in the record.
In order to get to the plea, there is no other way they could have entered the plea on the drug of abuse, but for the attorney having known that, that's what we were doing. We were pleading to having a quantity of some drug of abuse. Otherwise, we can't just say, well, we'll plea anyone. Like I said, to the
No, I'm
liquor
just
store.
saying that, from what you're saying, the only way we even have the toxicology report in the record is because they attached it to the brief.
That's correct.
So
You know,
we're
I
just kind
had
of
to
shooting in
demand
the
it.
dark.
Huh?
I said, we're just trying to kind of shooting in the dark, that's the only problem.
Correct. In part, you're right, Your Honor, but also looking at it from the point of view of Ms. Buzek, she's being walked through. Somebody has to represent her. And exculpatory evidence is the single most important thing you can get in if you're a defense lawyer.
And she didn't file a motion to withdraw her plea, vacate her plea or anything?
No, as a matter of fact, Your Honor, they hired me the day of the need for the appeal, which was kind of unique because the clerk's office closed down that day because of weather. So it was a kind of a short and fun, interesting day. But, Your Honor, I would just request that in this case, everything worked against her when in reality, most things would have worked for her had she been represented correctly. I don't think anyone would want that type of representation where they are blindly walked through when the information would have been there to not have put this young mother in for 30 days, have done all of the things that would be damaging to her. You know, there's a requirement that you represent, you know, not just walk through. And in this one case, I believe that it was rather ineffective. And certainly argued it would be a difference. I like what opposing counsel says about how he would handle it at trial. Yeah, I would have a lot of things I would handle at trial too. And a jury would certainly have a lot of reasonable issues to consider, none of which they had the opportunity in this case. Thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement, and a written opinion will be sent to both sides, as well as I had said in the earlier case, on the Supreme Court website and our website. Thanks so much.
Thanks, John.